Or good afternoon, I think, or where are we? Thanks very much for your kind invitation. Very interesting presentations this morning. I'm most definitely not an academic, so I'm going to be stepping out into sort of different territory now. And really, my talk, I'm going to look at, I want us to think a bit about communication. And because we've spoken a lot about capacity and decision making and all of those things, but there's a big piece around how that's bound up with the individual's communication and all of our communication and the people involved. So I want to talk about that, and I want to talk a bit about our service, the shameless plug, as Peter said earlier, and maybe about how advocacy will work with the ADM. I don't really know the answer to that yet, no more than anybody else. We're still kind of waiting to see how things develop. And I also want to draw a little bit on my own Scottish experience, because we did have capacity legislation coming up for 10 years ago or so now, and I just want to talk to you a bit about that, more than 10 years ago now. And then just to finalise with some comments on developments in advocacy at the present time in Ireland and how they might tie in with some of the pieces that Mary was talking about in terms of new legislative developments. So just to tell you a little bit about our service, we were launched in 2011, and under the Cork Act 2000 and the Citizens Information Act, there's statutory duty on the Citizens Information Board to provide advocacy to people with disabilities, and the National Advocacy Service provides that function. And there's a national manager, 4 regional managers, a team of advocates, and we are based on the principles of empowerment, inclusion, autonomy and citizenship. And just maybe to think about for a minute, how many people actually could we be talking about here in terms of the ADM? The last census showed that around 600,000 people in Ireland defined as having a disability, but the figure is probably a lot higher because there's a lot of misdiagnosis and undiagnosed disability. And the other piece is we need to think about how that disability might impact upon an individual's communication with the professionals involved with their care and how those professionals communicate with them. Other studies have shown that the experience of people with disabilities have a greater communication barriers than people who do not have disabilities by 66%. So if you just think about that, it's more than twice as difficult for somebody to communicate with a disability with a professional than for a non-disabled person. So I suppose I'm coming to you from the perspective of thinking, how can those professionals make that shift in reaching out to the individual with the different communication? And if you start to think of things in that way, it kind of shifts how you think about capacity as well. And I've just given you a little resource at the bottom of the page, just for those who might be involved in practice and social care who might be here. It's actually a Scottish resource, but it's really useful, and it's for people who are working in the area of social care and how they might communicate with people with disabilities. And our service was established because, research has shown that sometimes people with disabilities are not listened to, and they're not often given the chance to make their own choice. So I think both our earlier speakers have spoken about how the individual gets lost in the process, and especially when you get into the point of Circuit Court and the High Court, it becomes very difficult. You're in a huge process there. So I keep jumping on my slides here. And I think it's really thinking about, nearly everybody agrees we should all be treated the same and have the same chances and choices in life, and that's why our service was established. So what is our type of professional advocacy, and how does it work? So we really look to make sure that everybody has the chance to make their own choices, exercise their rights, be independent and be part of their community. And again, just come back to the earlier piece, sometimes for people with disabilities that can be harder to do because of the barriers they face. And our main focus is very specific. It's for those who are isolated in the community, residing in inappropriate accommodation. So that can be young people in nursing homes. I think there's around 1,000 people under the age of 65 in nursing homes in Ireland, which is very high if you think about it. Those who are unconnected to services, and those who have communication differences. And it's a focus on those who are in the most vulnerable situations. This is just the framework. We're probably all familiar with this. So that we operate in, there's the Disability Act, the Citizens Information Act, obviously our ADM whenever it comes in, and the European and international pieces. And it's also worth remembering that Ireland has really fantastic policy in the area of disability. It's really great if you just sit down and read it. It's the practical application of it is not so great. But if you just think about it for a minute, just some of the things that we have. with the National Disability Strategy, with Vision for Change in the area of mental health, with Time to Move On for congregated settings, which is 2011. At that point there was over 3,000 people living in institutional settings of 10 or more, particularly in the area of intellectual disability. The Value for Money and Policy Review of Disability Services in Ireland, which was looking at the connection between funding and access to day services. The HICWA standards and the Mental Health Commission standards. So that's just some of the environment that we're operating in. And when we work with somebody, what we do is, and it kind of sounds so basic, you meet with the person, like that's where you're starting from. We're not starting at what does the doctor say about them, what does the other professional say. We start with them and we gather information about them, we see if we are the suitable service for them, and we work with them to develop a plan in accordance with their wishes. And our role is to support them to have their voice heard. Where a person is not in a position to articulate their will and preference, and we're very much in that space of using that language, there are 4 internationally recognised approaches to, in the first instance, try to ascertain that person's will and preference. And if you're not able to ascertain the will and preference, then we look at the options available and try to determine how the course of action will impact on the person's quality of life. So sometimes you can think, well, how does that actually work? What does that actually mean? So if you have maybe someone who's non-verbal, what you would do is we have this witness observer, and you'd spend time with them in the environments, what they might do during the day, and whether or not they enjoy that, and how they might react by their behaviour, and how it might impact on the others around them. And that might tell you, well, does this person enjoy this activity, or are they absolutely bored out their skull and they'd rather be anywhere but here? And that tells you a lot, and you can build up an understanding of what's going on for that individual. We don't always have that opportunity, because sometimes when people come to our service, they're in quite serious situations regarding a breach of their rights. They could be, they could be in a locked ward or something like that, or they could be chemically restrained. And in that situation, we would use a rights-based approach and see what the impact is having on the individual. But always we are actually trying to understand where that person's coming from. The presumption is, in accordance with the Act, that the person has capacity. Now, I'm not going to go into this huge big thing, but it's just quite helpful. One of the other pieces, this is an English piece actually from Assist Services in Staffordshire. It's called the Equality of Life Domains. And it's just actually a really useful piece to think about. And if you take the second one there, community presence. So, having a sense of belonging to a local area by means of access and use. So you're living ordinarily in the community, you do that automatically without even thinking about it. You use your local shops, you use all your local services, your kids might go to the local school, you might work locally and all of those things. But for somebody who maybe has lived in a residential setting all their life, they're not actually availing of that. So the focus in this domain is to look at encouraging a high frequency of use and involvement in local and public facilities. And you're trying to avoid using segregated services or not using local facilities enough. And unfortunately, still in Ireland, we have a lot of people who are still living very segregated lives. The type of things we can help with, and for most people in this lecture theatre today, we probably take most of these things for granted, but if you put yourself in the position of maybe someone with an intellectual disability who has been in there from a very young age and is in adulthood now, like where to live, do you want to live in a group home in a congregated setting? Do you want to live on your own? Do you want to live in an apartment, a house? Do you want to live in the middle of a town? Or do you want to live miles from anybody on your own? Those types of things, we might take those options for granted and might not even realise that we've had that choice in how we design our lives. And really, that's the type of things we're looking at. So when I think of the Assisted Decision Making Capacity Act, this is the context that I'm thinking of it in, not necessarily in the circuit court, but thinking about how is it going to impact on these individuals in these situations. I'm just going to skip through this. And how we do that is we spend time with the person to find out who's involved, all the things that are actually described in the Act that Mary just outlined there. I'm trying to say to myself that we are already embodying quite a bit of that. Just want to give you one example. This lady contacted us. She had an acquired brain injury from a road traffic accident at quite a young age, and about 20 odd years had passed, and she was made ward of court because there was a reasonable insurance settlement made. And she wanted to be discharged because really the impact that it had on her was it affected her short-term memory, but she'd actually progressed quite significantly. In terms of her memory, had improved substantially. But she'd had about a number of years prior to that made an application to the Wards of Court Office to be discharged, and had been unsuccessful at that time. So it was really nerve-wracking for her to go through that process, and she couldn't get access to legal services. So we accompanied her to her solicitor to explain to the solicitor how she was actually in a position to go through this, because her capacity issue, if we can use that terminology, was very short term. So she might not remember what had happened that morning, but if she had it written down properly and it was explained to her, she would recall it properly. So it was really about the solicitor trying to step into the space of understanding how to work with her, rather than thinking, well, she can't remember what I just said to her 2 hours ago, so she has no capacity. And there's a lot of work done that's listed there, and the outcome of that was we supported her to have the medical assessments done, which again was extremely nerve-wracking, supported her through that process. And the outcome from that was that that lady was successfully discharged from wardship, and is now living happily in the community. In fact, she's sort of travelled the world immediately that she was discharged, because she didn't have to ask anybody if she could go off on holiday. So good luck to her. I just want to pick up, Mary was talking about all the principles in the Act, and I've cherry-picked one, which is the Presumption of Capacity. And, well, to me that's what this Act is. Like, that's why I think it's so exciting. Like, we have all these difficulties, and it's going to be really challenging for all of us. But, like, we have it in law. We're saying the relevant person is presumed they shall have capacity. And then we just absorb that and think about it, okay, there's all this other stuff to follow after it. But start from that and then work your way on. So what I'm saying is, our service, we are already, I'm hoping, I can say this about our service, that we've tried to embody that already and have done for a number of years, that we assume everybody that we work with has the capacity to make their own decision. Now that's really, really tough, because sometimes it doesn't seem that way, and sometimes our clients can't express their will and preference, and we have to go down other routes. I just want to talk a little bit how advocacy might interplay with the ADM. Look, it's going to be really tough for all of us. Like, I think what's clear, and again from the discussions at dinner last night, there's so many unanswered questions. We just don't really know how it's going to work. But, I'm willing and ready to embrace it, because I think it's really exciting, and I think Ireland is ahead of many here, and we've got lessons to learn from England and elsewhere. And I think Mary was talking there about best interests. Like, the current position is, for most people living in residential services in Ireland, like, they're not fully supported to access advocacy, and advocacy isn't fully supported for them, because most services are still operating on a best interest model and recognise family members as next of kin. Sorry, I keep jumping ahead. And there's no basis for that, but that's the reality, because as has been said, those individuals are not in a position to make an application to the High Court or to the Circuit Court to have a declaration that their mother isn't their next of kin. The reality is, if that's been the established de facto situation for decades, that's what goes on, and that suits a lot of service providers to have that in place. So I suppose what I'm trying to say, as well as thinking how are we going to apply the Act, I don't know what goes first. Is it the legislation comes down on top of us, or do we push up with a cultural shift and somehow or other the two meet in the middle? But I know that for everybody here, if you've come along today, you must have an interest in it. So we have an obligation to engage in a cultural shift so that we can bring Ireland with us. Just the specifics, Mary mentioned there the codes of practice. So there is a specific one there for advocacy, as well as a number of other professions, including the legal professions. And I think the NDA are going to commence work on these, or looking to start discussions about it. So it's going to be really interesting. The status of these codes of practice, I've heard different things, so I'm not actually sure what they will mean in reality, but it's a good opportunity to input anyway. Around the specifics of the different options available under the Act, with the decision-making assistance agreement, co-decision-making agreement, court-appointed decision-maker. There's also expert reports and capacity assessments. I can't stand here at this juncture and say to you, oh, the National Advocacy Service is going to be involved in all of these things and we'll do all these different pieces, because I don't know right at this point. I know there's a role for advocacy in all of these areas, because ultimately these are about individuals and their decisions. Looking at it, and this is kind of more my personal view rather than a corporate view, if you like there's possibly scope for us to act as decision-making assistants in certain situations. But it is a bit of a shift away, because you're becoming involved, whilst it's not a substitute decision, you're moving away from advocacy in terms of just supporting the person. Really, we would kind of balk against acting as co-decision makers or court-appointed decision makers, as really they are substitute decision-making positions, and that would really be against our ethos, which is to ensure the person is at the centre of the process and has control over the process. Given that we're going to have capacity assessments and there are going to be expert reports, who's going to make sure the person has their voice heard in that process and that they have some influence over how that expert is appointed, or who makes the capacity assessment, and that they're not just railroaded in, as Peter said, this sort of professional colonisation? How do we avoid that? And there must be a role for advocacy in there to keep bringing it back to the individual. So, whilst a solicitor and barrister and a psychiatrist and a speech and language therapist and whatever else, and an occupational therapist, whoever else you want to throw into the mix, but you keep bringing it back to Jimmy, who's having a really bad time of it, sitting staring at four walls in a locked ward. Keep bringing it back to him and say, look guys, that's great, you're all talking about it, but what's going on for him? So that's where I would see we would keep coming back. As everybody else has said, resources, training, it's going to be massive. Every time I look at it, I just think, for any aspect of the Act, there's just no way it can come in unless there's huge input of resources, not least for the Decision Support Service. And other professions, so advocacy can be perceived as quite adversarial, a lot of service providers might perceive us that way. We're really not. We're really just around kind of saying, let's just keep bringing it back to the individual, be the voice of the person. So if someone's having a negative response to that, I would be putting it back to them and think, well, why are you responding in that way? Where are you at with it? And it's really about reaching out to everybody in this room and all the connected professions that will be involved, is to challenge ourselves about how we think about capacity and support in decision making. I just want to move on. My slides are jumping ahead of me. They must know we're pushed for time. This is not my will and preference. So I'm just going to touch very briefly on my experiences in Scotland as a solicitor, because I know there's a few capacity nerds in the room, so we all like to know what goes on elsewhere. And look, if you thought Wards of Court was bad language, check this out. Curator bonus, curator ad litem, tutor dative, tutor at law, for adults who are incapax. We were still in the Latin, So that's where we were at. And it was an absolute nightmare. It was an absolute nightmare. You could not move. The just generally accepted position was that if somebody came to you looking to do anything in connection with any of this, you couldn't do it unless they happened to be a millionaire, in which case they couldn't get access to their money anyway. You couldn't do anything. And the appointments, the people who were the curators and the tutors were normally solicitors or accountants, and who were just concerned with protecting whatever estate was there. So they had no interest in the person's quality of life or what they actually chose to do. And the approach and the requirement was to preserve the estate and act in the best interest. So that's where we were. It was overly restrictive, ignored the realities of everyday life, and didn't pull all together all the different strands that were going on for individuals. So we had our legislation, and you look at the language now, adults with incapacity. We thought it was really fantastic at the time. Now you look at it and go, geez, that's what we called our act. It's kind of cringe-inducing now at this point. So that was 2000. And then look at the preamble. An act of the Scottish Parliament to make provision as to the property, financial affairs and personal welfare of adults who are incapable by reason of mental disorder or inability to communicate and for connected purposes. So good bits and bad bits, because it recognises it's a piece around communication, not necessarily around the actual mental capacity, if you like, but the whole piece around you're incapable is still there. But the general principles, section 1.2, there shall be no intervention in the affairs of the adult unless the person responsible for authorising or effecting the intervention is satisfied the intervention will benefit the adult. So it's benefit as opposed to best interest. and that such benefit cannot reasonably be achieved without the intervention. So it's a piece about whether it can be, it's a reasonableness argument to it. So it's okay, and then it goes on to say it should be the least restrictive option, and that the past, present wishes and feelings of the adults, so far as practicable, should be taken into account. And it's interesting actually at that early point, it says there, so far as they can be ascertained by any means of communication, whether by human or mechanical aid. So like even back in 2000, we're looking at saying, well, how does technology input into how a person communicates? And pulling that in, So that's, I think, was a strength to the Act. So then in practice, and this was my experience, most applications were direct to the Office of Public Guardian. We found it, in my firm, certainly inexpensive compared to what went before for clients, reasonably accessible compared with the previous procedures. There was an inbuilt process for advocacy, and legal aid was available for the adults where they were financially eligible. For intervention orders, as we called it, so that was if you wanted to, or if there was a need to realise assets, say, to pay for a nursing home, that could be done through the local sheriff court. So that's kind of akin to the circuit court here, sort of a hybrid between a district and a circuit court here. I find that my personal experience was it was very quick and considered judgments, but I just might have been lucky with our local court. And the discharge of the curator bonus through the local sheriff court was very quick and accessible. I think those slides are the wrong way around. And it also introduced welfare powers of attorney for the first time, welfare guardians, financial guardians, and intervention orders. So it's very much a guardianship-based model, but at least there was a recognition there of the personal welfare issues. So this woman I worked with, so she was actually about the same age as me, and she was involved again, we're back to road traffic accidents, crossing the road when she was aged 15, and she had an acquired brain injury to her frontal lobe, and the consequence for her was it made her extremely disinhibited and impulsive. So she'd hop on the bus from Glasgow and go down to London and just stay down there doing whatever she was doing for months on end. And her curator bonus was an old retired accountant in Glasgow. Like, they couldn't have been more at the opposite ends of how you chose to live your life. She was all joie de vivre and let's do this, come on, let's go. And he'd be like, well, let's weigh up all the options. And it's just, it's just a disaster. So he just actually exercised enormous control over her because he controlled her money. So he couldn't stop her going down to London, but he could not send her money when she was down there, if you see what I mean, So we actually made the application to the local court to have the accountant discharged, and her mother, who was an excellent support to her, appointed, because she wasn't able to manage her own financial affairs, and she did have a large settlement. So her mother was appointed to be her financial guardian in that situation. Gone was a curator bonus, and it was fantastic because her mum gave her loads of free rein. Like, it wasn't a case of, well, you have to, I'll give you £10 a week and tell me what you spent it on. It was fantastic, and it really transformed that whole family's lives, because she had independence and autonomy, and it made her in a much better frame of mind. But she had the support of her family, and her mum could keep an eye on her. So it was really a great result. But not surprisingly, Cheshire West, everybody in Scotland got in a panic about it as well. So there was a consultation. The Adults with Incapacity Act didn't deal with deprivation of liberty, and we have a separate regime for mental health tribunals, which is actually quite similar to here. So there was a consultation just closed there, just on 31st of March of this year. And interestingly, this is just an early bit, that the approach the Scottish Government are taking post this Law Commission report is a sliding scale of deprivation of liberty. So if you happen to be in hospital because you're, say, drunken, disorderly or intoxicated and you're a risk to yourself, you can be held there. That's not, it's not thought that you'll have to have a court process to keep you there for that period. They're saying that that's just a practical solution. It's a very Scottish approach. How can we be pragmatic about it? So they are having a sliding scale of the difference, making a distinction between hospital settings and community settings, because you're more likely to be deprived of your liberty in community setting, as I understand it. So it's just a different approach. They're also currently consulting on the draft delivery plan of the convention, which is just quite interesting because it kind of chimes with what's going on here at the minute too, around the roadmap to ratification. And I was just looking at the Law Society of Scotland's response to this, and just published last week, and they've come out very strongly saying that actually the implementation of the Adults with Incapacity Act has now become really problematic. They're saying it's very fragmented because we have the sheriff courts with jurisdiction for the Adults with Incapacity Act, and we have the mental health tribunals, and there's separate legislation around people living in sort of group homes and things like that. And there's not the specialist expertise that they thought would develop through the sheriff courts hasn't developed, that it's still very much the sheriffs are dealing with it in a connection along with other business. So there's problems there. And Adrian Ward, who would be very well respected in Scotland in this whole area, who's the convener of the Law Society's Mental Health and Disability Committee, said that the Act was world leading in its time, which I think it was, but it's now in desperate need of updating, and we can see now even the language of it is outmoded now, to ensure people at risk are protected. And he's saying there needs to be a massive and comprehensive review of all three areas of legislation, taking account of current and European human rights standards for people with intellectual disabilities. And the reason I'm giving you that quotation is just to say, like, Ireland's here at the forefront of it. We're about to go into this, we're about to implement it, and here's a similar sized jurisdiction grappling with it and has come unstuck now at this point, because what I was reading was the Law Society's response were saying, in fact, in reality, most of the sheriffs are still using a best interest approach because they haven't really got their head around the paradigm of will and preference and all of that, so it's still going back to that. So it just shows you how complicated this is. And I'm just thinking about, we need to think about, for us now going into this, where I'm standing, we're ignoring the deprivation of liberty piece at our peril. And I was saying ignore, I know there's bits and pieces going on, but I just think it needs to be done. I can't see how we'll be compliant unless we deal with it. And then at the more local level, there's access issues for legal aid that need to be thought about, local court access issues, like how can people access the courts properly and meaningfully, and how user-friendly are those systems going to be. I'm just going to very quickly finish to tell you about some current developments around advocacy, because this stuff is all interconnected, and it's to try and think about it as a landscape, like not to think of the ADM as this one piece, but to think of it as much broader context. So you'll recall that there was the HICWA did an investigation into Portlaoise Hospital, published their report at the start of last year, that primarily focused on the maternity services. Their number one recommendation from their investigation was for the establishment of a patient advocacy service for people using healthcare, primarily hospital settings. And the outgoing minister, Leo Varadkar, so who knows where this will all be now, but he did make a commitment to establish this, and that this would come directly under the auspices of the Department of Health, that it wouldn't be funded by the HSE, because it would be seen as a conflict of interest. Well, it would be a conflict of interest, that it'd have to be directly funded by health. So that's sitting there, pending whatever outcome we have of the current impasse, wherever we go. And we'll see where that goes. There was also a Oroptus committee in November of last year of Health and Children, and they published a report on the role of advocacy in health and social care services in Ireland. I've given you the web link there. And there's a number of, including ourselves, in attendance there. There was Inclusion Ireland, SAGE, Advocacy and the Ombudsman. And what they recommended is that the National Patient Advocacy Service, the piece I've just referred to, that they should coordinate advocacy services. So there's a kind of, I'm not going to go on to it, but there's a plethora of different advocacy services in operation in Ireland, and they're all doing different things and different models. Our service is probably the biggest paid professional service and has a statutory body behind it. So we are in a kind of slightly different position. But there are a number of different models there, and I think it can become confusing as well, because advocacy is batted around as a term. So they recommended there should be, the service should be established, and there should be a framework and a code of practice. And this would ensure all professional and voluntary advocates operate to the same standards. So that's just to give you that piece. So really, in conclusion, I just wanted to say that I really broadly welcome the Act. I think, some pieces around it, they're kind of terrifying, and we don't know where they'll be, but I think, it's changing. It's going to take a long time to bed down how it will work in practice, but it's a great change, isn't it? Like, to recognise people have capacity to make their own decisions, but they might need help, instead of, you can't make your own decision, you're a ward of court, or we'll just de facto carry on. I have some reservations about the emphasis on functional capacity. Look, I know there has to be, in reality, I'm a pragmatist, there has to be something there, but I think, you know, we need to be careful we don't get too focused on that and start from the presumption of capacity. And there's a change of culture required more than anything, and that's what we need to do. We need to start talking about that, and we all need to think about how we communicate, go back to what I started with, and how you can go into the space with the person and stop assuming that they can't communicate with you, and maybe we're not communicating with them, and go into the space with them where they're at in their lives, and then that might change whether or not you actually think they have capacity to make a decision or not. I'm just going to finish with our shameless plug, which is our national phone line at the bottom. So thank you very much.